And I emphasise that this order affects not merely those who are in court, but all those who are watching and listening to these proceedings remotely on the internet. Secondly, we have, I think, already directed that the new point, which I think it's the respondent wishes to raise, can be dealt with on a de bene esse basis. We have similarly on a de bene esse basis looked at the further fresh evidence, and we won't take up time during the hearing with argument about whether permission should be given. We'll deal with that when we deliver our judgments in due course. Thirdly, although we are back mercifully and delightedly face to face, we are now habituated to using electronic documents on this side of the court almost entirely, and we would encourage you therefore just to give us electronic page numbers, although for courtesy to each other you may want to give another one as well if your physical page numbers are different. Finally, there appears to be some uncertainty or fuzzy-edgedness to the timetable for council submissions. There seems to be a sort of floating quarter of an hour. But is that because you can't agree?
Oh, no, it's not. I just hadn't made up my mind that I'll take 2 hours to 2 hours 15 minutes. So I'm slightly hedging my bets with the court's permission that I will finish around 12:30 or 12:30 to 12:45. We agree Mr. Sachdeva has 2 hours, my lord.
So if you run over, it just comes off your reply?
It does.
Well, that's perfectly acceptable. Yes, thank you very much.
Thank you, my lord.
Is that the end of the church notices?
End of the?
Church notices.
It is the end of the church notices. Yes.
Could I just say I can't connect to my screen?
Oh dear.
I'm happy to start, but right.
Could you get that message through to IT, and if it causes you a need to pause, let us know. Let me check if I can.
The introductory 10 minutes of my submissions, I hope, won't involve too much taking my lords and ladies through the bundle, so it may well be I can begin and the IT difficulties can be resolved. I hope, my lady.
Very well.
Thank you, my lord. Well, I appeal with Mr. Brownhill and Ms. Law on behalf of the appellant by his litigation friend, the official solicitor, Ms. Castle, who is present in court. The respondent authority, my lords and my ladies, is represented by Mr. Sachdeva QC, Mr. Whitten QC, Mr. Rockkeane and Ms. Patterson. I have a shortish introduction and then I will develop the outline of my submissions and then say a little about my client before getting into the meat of my submissions. We say, my lords and my ladies, that the issue in the appeal is what is the decision in relation to the matter for the purposes of Section 2 of the Mental Capacity Act, and what is the relevant information for the purposes of Section 3 in the context of sexual relations. It is clearly a sensitive and difficult matter. This is clear from the differing approaches over around 10 years of first instance judges of the Court of Protection between around 2011 and 2021. We say it's important to note that during those 10 years, given the inquisitorial nature of the Court of Protection, no judge has determined until the Court of Appeal decision under appeal that P's partner's capacity and consent to sexual relations forms part of the relevant information. And I acknowledge at once, my lords and my ladies, from the very outset, that P and P's partner's consent is, of course, fundamental. And nothing we say should be interpreted to diminish the fundamental importance of the law, which requires the consent of both, and both should have the relevant capacity to provide their consent. We entirely, of course, accept non-consensual sex is wrong, which diminishes our common humanity. Our argument through this difficult field is essentially threefold, as will be seen from the written case. First, that the Court of Appeal departed from the language and the purpose of the Mental Capacity Act when it made the interim declaration the subject of the appeal. Secondly, that Parliament has set out the respective roles of the Court of Protection, the Mental Capacity Act, the Criminal Courts and the Sexual Offences Act. and that ultimately the concerns that the respondent has in respect of my client can be met, we say, by a sexual risk order if appropriate. And when both of those functions, statutory functions and roles of the courts, are properly understood, we say this court's interpretative obligation pursuant to the Human Rights Act, Section 3, that should lead to the interpretation of Sections 2 and 3 of the MCA in the manner set out by Mrs. Justice Roberts at first instance. And I approach my submissions, my lords, my ladies, on the basis of the Court of Appeal's reasoning, which is to cast the relevant decision as capacity to engage in sexual relations and to set out the relevant information, as the Court did at paragraph 103b of the judgment appealed, namely the fact that the other person must have capacity to consent to the sexual activity and must in fact consent before and throughout the sexual activity. I will also try to deal with, if this court were to take the view that the relevant decision in respect to the matter is consent to sexual relations, what should be the relevant information in that context? And of course we recognise in this broad canvas of this court, it's open to the court to reframe the decision and the relevant information. Whilst our submissions, my lords and my ladies, are of course focused on my client's particular situation and the interim declaration, the official solicitor as litigation friend of last resort for many Ps, many vulnerable, learning disabled, cognitively impaired, neurodiverse, elder people with dementia who are joined as parties to the Court of Protection, is very much focused on securing from this appeal a workable, straightforward test which can be clearly applied in this difficult area, respecting the rights of the learning disabled and those with impairments or disorders, whilst ensuring the protection of P and protecting the wider public from possible harm. If I may make two further short points, I recognise at once from the outset that the constitution of the Court of Appeal below, including the President of the Court of Protection and Lord Justice Baker in particular, is a particularly strong welfare Court of Protection court, and Lord Justice Baker in particular, sitting at first instance and in the Court of Appeal, has been instrumental in developing the jurisprudence in this difficult area, and I must acknowledge that from the outset. Secondly, it is a highly complex area, and I recognise both that the submissions that I make are to some extent difficult because of the context, and systematically it is difficult for any court to alight upon the correct legal solution in such a complex area as the intersection of disability and human sexuality. And in some ways, we say it's right to acknowledge the court is being asked to find the least imperfect solution to a complex human problem. I'm just pausing there. I don't know if my Lady Arden has managed to resolve screen issues.
No, I haven't. And I can't really deal with the IT's request to me at the same time as listening to you.
Yes, well, I think we'd better pause.
I think so. Here's something.
Do you think this is a pause and retire, or it probably is, isn't it, briefly? I'm very sorry.
No, of course.
It's odd. We fought our way through the remote hearings in the pandemic with a minimum of IT upsets, but we seem to be encountering one or two on our return. We have only just restarted face-to-face hearings, so we'll be as quick as we can. I think you can assume it probably won't be much more than 5 minutes, and we'll do what we can.
My Lord, thank you very much.
Thank you.
Yeah, please continue. I'm sorry about the delay, but we did stick within the 5 minutes, I think.
That's impressive by the IT people. So I shall carry on, my lords, my ladies.
Please do.
I have 8 points which I will develop in the course of this morning. The first relates to the approach to capacity in the Mental Capacity Act generally. And we say what's important about that is the overall thrust of the court's role and the Act is to protect P and promote their autonomy, not questions of wider public protection. The second point is in respect of the proper interpretation of Section 2 of the Mental Capacity Act, and in particular, what is the decision and the matter. And that's important because it frames the relevant information, and we say the proper interpretation of Section 2 in this case is that the decision is to give or withhold consent to sexual relations in respect of the matter, which is consenting to sexual relations. And it's not to engage in sexual relations. Point 3 focuses on Section 3 of the Mental Capacity Act. What is the relevant information for P to decide for himself or herself to consent to sexual relations? And it will come as no surprise, we say that P's sexual partner's capacity and consent is not relevant information for P to give or withhold his or her consent. Point 4 is to deal with the R.N. Cooper person-specific approach, and I will have traversed some of that ground by the time I get to it.
Would you just explain in very simple words what you mean by that?
My lady, what I mean by that is, or what I understand the point the respondent wishes to raise is that capacity should be assessed in respect of P's particular sexual partner that they have in mind, and it is not issue or matter specific.
The person, sorry.
But you don't mean by that, I would assume, that the official solicitor or the local authority has to come to court every time there's the suggestion that a decision about whether to have sex with someone is facing P, or do you mean that? I still struggle to understand what this person's specific thing is.
My lady, I don't want to avoid the question, but it might be best if I set out my submission to when I get to point.
Just bear in mind that I also need some help with that.
My lady, of course. On our overall approach to say it's impractical and unworkable because there would be so many decisions falling to be made. It may well be some of those should come to the Court of Protection. We don't know. I mean, I will hear how Mr. Sachdeva puts his point.
If you're not clear what the point is, wouldn't it be, it's subject to my lord, of course, wouldn't it be better if we heard it after we'd heard it from Mr. Sachdeva? There are so many different interpretations of the point.
I'm entirely happy to proceed as my lady and my lord.
Let's see what clarity we get when you get to the detail of it.
Lord, yes.
Mr. McHenry, but bear Lady Arden's warning in mind.
Thank you, my lord. Point 6 is in relation to the criminal law, and we say that neither of the approaches to the test for capacity to consent to sexual relations in the Sexual Offences Act includes that the complainant understands that their partner has capacity and must consent. And the point made in our written case, my lords, my ladies, is it doesn't make sense to have different tests which will weaken protection. Point 7 is, in particular, sexual risk orders, and that Parliament has determined, with the appropriate protections, that this is the scheme to use to protect the public from the risk of sexual harm, not by the way of identification of Section 3 Mental Capacity Act relevant information. And the last point is the Section 3 Human Rights Act interpretive obligation. Can I say a little bit, if I may, about my client before I turn to those submissions then, because he is, from our perspective, the centre of this. As my lords and my lady will know from the papers, he's 38. He lives in the Respondent area. It's not where he was born and brought up, but he's lived there since 2014. His family live in another part of England. I don't ask my lords and my lady to turn it up, but you will see at page 454, using the electronic bundle referencing, that he's described as a very likeable man with many hobbies and interests. He likes arts and crafts and making jewellery and making mirrors from driftwood. He likes to socialise, read, play bingo, enjoys dancing and games. The effects of his epilepsy and his Asperger's syndrome and his IQ of around 76 do make him vulnerable, and he has some disinhibited behaviours. He lives with two other gentlemen in a supported living placement where they have full-time support provided by care staff. He is described as desperate to be popular, and again, without turning it up, at page 459, you can see that when he's challenged about his popularity, it causes him much upset and anxiety. It's also recorded on 459 that he wants more than anything to have a girlfriend, and Mrs. Justice Roberts records that. Whilst he lives with two other gentlemen and has some contact with his family, he is largely supported by paid staff, and he lives for a very large part of his life with people who are paid to be there to support him. He is a young man with no criminal convictions. He has not been subject to any of the civil sexual harm prevention orders, sexual risk orders. No findings have been made against him in any civil court. Seen against that background, it's important to state some obvious points. The expression of sexual identity for him, and indeed for many humans, is central to their identity. Sexual life may be, for many, the gateway to a relationship. And for many, the expression of our sexual identity defines who we are. Sexual life can lead to relationships, creating intimacy, companionship and love, often a shared home, and a sense of identity as a couple, as a we, or it can be the basis to begin to form a family and view your identity as, again, a we or a family. Being deprived of the ability to express his sexual identity whilst the interim declaration remains in place has a heavy burden on JB. His current existence is shorn of much of the warmth many of us take for granted, and we say he leads a relatively impoverished life, surrounded by people who are there because they're paid to be there. The implications of the interim declaration continue to be, we say, of profound significance for JB and go far beyond what might be considered the immediate gratification that comes with sexual intimacy and impacts on his happiness and identity. The respondent's case in writing says much over 5 pages about the risks he poses to others, but says very little, or nothing indeed, about the risks to his well-being of loneliness, a lack of fulfilment, and the inability to develop meaningful relationships and develop his identity and the happiness he seeks. And whilst the debate in this court necessarily will be a high-level one, we say it's important not to lose sight of any of that. Turning then to point 1, key points regarding the MCA's approach to capacity. Capacity is, of course, the first point of 4 to make. Capacity is the gateway to the jurisdiction of the Court of Protection, and the Court must be concerned with the promotion of autonomous decision-making. And if I may ask, my lords and my ladies, to turn to the decision of Mr. Justice Hayden, it's at 1239 of the bundle. Tower Hamlets and NB. No. I'm only using 1239. You're not using. It's 1239 of the E-bundle. Tower Hamlets and NB 2009 EW COP 27. It's one of the decisions discussed in the respective written cases from July 2019 involving capacity to consent to sexual relations. But perhaps if I can ask my Lords and my Ladies to turn to paragraphs 27 and 28, which is at E-bundle number 1249. And I ask my Lords and my Ladies to read paragraph 27 and paragraph 28. And we say what's important about that is the focus on autonomy, even although this is an assessment of someone's capacity in the MCA and in the Court of Protection. Also important is paragraph 56, which is at 1257 of the E-bundle, paragraph 56. And I ask my Lords and my Ladies to also read that.
Sorry, page reference again.
Yes, my lady. It's 1257, paragraph 56, please.
Thank you. When looking at the MCA, did you take into account whether there was any reference in the pre-legislative materials to the situation where the court was having to consider the relationship between the person whose best interests they were looking after and a third party?
In the context of
exercising the best interest jurisdiction?
Not that I can recall, my lady, no.
And, I mean, it obviously will be accepted that under Article 8 of the Convention, one must have regard to both parties' interests in making a decision.
One of the arguments I will develop in respect to sections 2 and 3 is that the relevant decision in respect to the matter is a decision for P himself or herself to make.
Yes, but that doesn't alter the point. When the court makes an order, as a public authority, it must do so in a way which is compatible with the Convention. And it doesn't matter how you have formulated the decision. If the effect of the decision is to engage Article 8, then the court has to consider whether Article 8 interference is justified.
We would say that there isn't authority which shows that the determination of the relevant information should be taken in the context of the protection of others.
But that doesn't take account of the Human Rights Act angle, doesn't it?
The Mental Capacity Act is concerned with assessing and, where appropriate, taking decisions where P lacks capacity, yes, and must be seen in the context of the wider criminal justice system.
But the point remains that the Human Rights Act has to be complied with, unless the section is incompatible with the Convention. I'm not saying that.
We would say, my lady, that there is nothing incompatible with Article 8 when the decision is correctly framed for the purposes of sections 2 and 3, that it's a decision to withhold or give consent for P taking that decision for themselves.
Does not engage Article 8.
The court pays no attention at all to the interests of the other person under Article 8.
The court is concerned with determining whether P can make that decision for themselves. That is a decision in respect of their decision-making ability to provide or withhold their consent. And we say that doesn't engage other sexual partners.
Well, I'm not going to pursue it now, but I would like to know at some point quite clearly how that satisfies Article 8.
Lady, yes. Moving forward to the case of Tower Hamlets and PB, which is 2020 EW Cop 34, and that's at page 1261 of the bundle. And this is not a case, it's another decision of the Vice President, Mr Justice Hayden, from 2020. It doesn't concern capacity to consent to sexual relations, but concerns residence in care. But if I could ask, please, the Court to look at paragraph 30 on 1269. Again, the important point is the summary of the importance of guarding against imposing too high a test of capacity, seen in the context of issues of residence and running the risk of discriminating against persons suffering from a mental disability, which is a point that runs through all identification of relevant information, we say. The second important all-encompassing approach to questions of capacity in the Act and for the Court of Protection is set out in the decision of York City Council in C, which is 2013 EWCA Civ 478 at 2903 of the bundle. This was a decision of Lord Justice Richards McFarlane, as he then was in Lewison, concerning the issue of whether a married woman had capacity to go and live with her husband. But Lord Justice McFarlane, as he then was, at paragraphs 35 and 37, which is at 2920, make some important observations about the overall approach to capacity. So if I could ask the Court please to read paragraph 35. And 37, please. Mr Sachdeva asked that I ask you to read paragraph 36 as well. That is important background to paragraph 56, please, where Lord Justice McFarlane really gets to grips with the test for capacity And if I could invite my Lord and my Ladies to read 56, and his analysis of the core determinative provision is in fact section 2.1 of the Act.
If I could just take you back to page 2917 and a quote from Mr. Justice Mumby in relation to marriage. The only question for the court is whether E has capacity to marry. The court is not concerned, has no jurisdiction to consider whether it's in E's best interest to marry or to marry S.
Lord, yes.
That, to my mind, moves away from the statutory test, and that is, what is the information relevant to the decision to marry? Say, for instance, a patient, and I take an extreme example, wanted to marry someone who was abusive and sexually abusive. And provided that the patient understood the risks, they would be free to do so. They would have capacity to make that decision. But to my mind, in that passage, the two are being elided, conflated. The first decision is, what is the decision? Then is, what is the relevant information in relation to that decision? And are you contending that somebody who wishes to marry somebody who could commit the most heinous crimes on the individual wasn't relevant information?
The assessment of capacity in respect of marriage has been described as being issue-specific. So somebody either has that capacity or they don't.
Well, I'm challenging that. And I'm just wondering why it's being contended and continues to be contended that it is issue-specific when, for instance, part of the relevant information under the Act may very well be whether the other individual is going to commit the most awful crimes on the patient. And so long as the patient understands that, takes the risk, that's autonomy. But why is it that that is not relevant information?
The traditional view, my Lord, has been that that would import a father of the bride test, and that if one understands the essentials of marriage, one therefore can exercise the decision to marry. There may be more complex issues regarding your contact with that person, and the person may not understand that contact with a violent partner.
So one could marry but not have contact with the individual?
Well, it may well be a declaration could be made that they have capacity to consent to marriage, but that it is not in their best interests to have contact with an identified person.
But you can't get to the best interests until you've decided that they lack capacity.
My Lord, of course.
And so if you're saying they lack capacity to make a decision as to whether they should have contact, and lack capacity as to whether they make a decision as to whether they have sexual relationships, why is it that you can't take into account the characteristics of the person they wish to marry and the person with whom they wish to live?
Because the policy behind that, as I said, my Lord, is that it would import a father of the bride test. If one understands, as Mr. Justice Mumby has made it clear in pre-MCA cases, the basic relevant information regarding issues like marriage and sex, then one exercises that capacity. The protective scheme would come in where the more complex issues of contact.
The first stage is to understand what the decision is. The next stage is to understand what the information in relation to the decision is. Are you saying that the information in relation to the decision should exclude a situation where the other person could commit a crime on the patient?
My Lord, what I'd like to do is go to sections 2 and 3 and explain our construction of them, because right. I'm in large measure of agreement with what my Lord says regarding the proper approach.
Yeah. But in answer to my question, then, what is the answer?
Is that in the context of P's capacity to marry?
In any decision at all, do you take into the defining? There is no statutory definition of relevant information. That is left to the good sense of each individual judge hearing the case.
My Lord, yes.
And I'm posing the question, that is, if the relevant information is that the other person could wreak harm on the patient, isn't that relevant information that the patient must be able to understand?
My Lord, yes.
Yeah.
And the court would consider that in the context of capacity or residence. And the court would say that this is information relevant, that P must understand that this potential partner or actual partner is abusive or violent. And that is the day-to-day work of the Court of Protection. But questions of contact will, as I will take my Lord's Melody too, I hope if I have time, Mr Justice Mumby makes clear, long-term contact is a much more complex issue than capacity to give or withhold your consent to sexual relations.
And in sexual relations, you just leave out of account the other person.
I will explain why, because as my Lord says, it's a question of framing what is the decision and the relevant information.
Yes.
And once you frame the decision correctly, we say it is clear that the consent of the other person is not relevant information, and I'll explain why very shortly.
Okay. Sorry.
My Lord, yes. Paragraph 56, that the key takeaway from that is it's not simply a decision, it's a decision in relation to a matter in section 2.1 is the core determinative provision. And one of the criticisms we make of the Court of Appeal's decision is, in effect, they've gone straight to section 3 and said, what is the relevant information for the decision? And they've overlooked the importance of section 2.1. The other two points I make in section 1, and I'll make this point, the third point, very, very quickly, is that there is no case law which says the relevant information should be framed by analysis of public protection or society at large. The only cases the respondent relies on all relate to best interests, and perhaps I can just provide, for the purpose of time, the neutral citation and the page number without going into the issues. But the first one is at page 1646. Neutral citation is 2013 COPLR, which is Court of Protection Law Review, 463, decision of Mr Justice Moore. I'm not asking you to turn it up. Y County Council and ZZ. The second decision is at 1192 of the E-bundle, Birmingham City Council and SR, neutral citation, 2019 EW COP, England Wales Court of Protection 28, decision of Mr Justice Levin. And the third decision is at 1627, Secretary of State for the Home Department and Scripal, 2018 EW COP 6, decision of Mr Justice Williams. Those are the three decisions set out in the respondent's case. None of them deal with section 2. And there isn't case law that says relevant information is framed by a public protection imperative. And then the fourth point we emphasise is that capacity to consent decisions are only considered as against lawful decisions that are open to P, the person being assessed, and that's set out in our written case at paragraphs 22 to 31. So there are many decisions that the capacitors take every day but don't fall to be considered by the MCA or the Court of Protection. For example, P wishes to move into a mansion or a much larger house but has no money to do so, then there is no decision that falls to be made, and invoking the court's jurisdiction is academic. For example, a doctor is not prepared to provide a course of treatment because it's unethical, so no decision falls to be made because there's no decision on offer for P. So theoretical decisions or decisions not open to P don't fall to be considered in sections 2 and 3. So moving to section 2, what is the decision in the matter? Is it consent to sexual relations or engage in them? Our written case is set out at paragraphs 12 to 21, pages 71 to 73. And we say there's a long and a short answer here. The short answer is section 27, which I'll take the court to shortly. And it unambiguously states what the matter is in relation to the decision. Can we begin, though, with section 2, which is at page 860? And I know, my lords, my ladies will have looked at this and read it many times in advance of the hearing, but as Lord Justice McFarlane, as he then was, made clear, the core determinative issue in terms of capacity, section 2.1, for the purposes of this Act, a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. Now, what is important there is it's not simply a decision, it's a decision in relation to a matter, and it's a decision for himself or herself to make. It's not simply a decision, and that's reinforced if one goes over to 861 of the bundle, because section 3 is introduced for the purposes of section 2. A person is unable to make a decision. And that emphasises the core point Lord Justice McFarlane was making in York, that section 2.1 is the core determinative feature. What we say is the Court of Appeal did not consider clearly enough what was the decision in relation to the matter, and considered instead the separate question, not supported by the language of the Act, which is what information would a capacitous person consider in reaching a decision? Section 27.
Only the expression reasonably foreseeable consequences in section 3, subsection 4, is wide enough to include the reaction or effect on third parties.
Milady, it very much depends upon what the decision is in respect of the matter. I mean, it may do, depending on the decision in respect of which the relevant information must be assessed against.
But the fact that it may do is enough, isn't it, for the purposes of meeting this argument? If you were saying, well, he has to make a decision for himself, implying that he only has to look with his own interests in a silo. But when you get to subsection 4 of section 3, it's clear that he has to have information about the reasonably foreseeable consequences. And that may involve third parties. The effect on third parties, as well as the effect on him of the effect of third parties being affected.
We say that would be going too far. If the decision is capacity to withhold or give your consent for yourself to consent to sexual relations, then that wouldn't engage the capacity and consent of a sexual partner.
Yes, I know that's your case.
I don't understand why you define it in that way. Why do you not define it as engage in sexual activity?
Because that's not the language used in the Mental Capacity Act, my Lord. If one goes to section 27, if I could take my Lord to that, which is at e-bundle number 868.
This is a section which is meant to prevent people from taking the most personal decisions. It isn't defining the matter in section 2.
Well, we say, in effect, it does, because it says nothing in this Act permits a decision on any of the following matters to be made on behalf of a person. And obviously, I rely on 27(1)b, consenting to have sexual relations. So if you're concerned with what is the matter, Parliament has set it out. It's consenting to have sexual relations.
That's one of the matters.
What Parliament has done is simply extract from a completely general requirement to look at capacity in relation to decisions in relation to matters, a particular type of decision where stage 2 of the process, that is a best interests making of the decision on behalf of the incapacitated person, can't be done.
If Parliament took the view that the matter was engaging in sexual relations, we say it would have said so here. But
there's all sorts of matters which are routinely dealt with by the Court of Protection about, say, financial dealings, which are not referred to at all. So how can this be an exhaustive list when the court's taking decisions all the time about capacity to take decisions in relation to other matters which are not referred to here?
But where Parliament has expressed a view as to what the matter is in respect to something as sensitive as sexual relations, it has said it's consenting to have sexual relations, not engaging in sexual relations. And we say that that's right, and it certainly is supported by the pre-MCA case law, because it views the matter and the decision in that way. It's consenting to have sexual relations because the civil law and the criminal law prior to the MCA, we'll turn to this soon, has been aligned. So there's a legislative background to it, and there's the language of the Act.
Can I just come back to your notion that this is all about making decisions for yourself? The common law of negligence in this country requires us, when going about our business or our pleasure, to take reasonable care not to injure other people. It's called the neighbour duty. Are you saying that that is wholly out with taking a decision for oneself? Namely, that part of taking a decision for oneself about whether one drives at a certain speed or drives a certain kind of vehicle, it's not about taking a decision for oneself to the extent that it involves the question, am I going to be at risk of injuring my neighbour? My instinct is to think that's absolutely part of taking a decision about oneself.
My Lord, it depends on what the decision is.
I'm not here thinking about cases involving sexual relations, you understand, but just looking at bearing in mind the extraordinary breadth of Section 2, seeing how your concept of about yourself works in another context. Sorry, I interrupted you.
Yes, my Lord. One of the distinctions we draw is that one is concerned with effectively the sexual nature of the act, sexual relations, not the lawfulness of sexual relations. If one imports the lawfulness of sexual relations, then the relevant information is expanded. But a proper reading of Section 2 and 3 doesn't take you to the lawfulness of the decision. And that has been how the courts to date, until the Court of Appeal, have interpreted consenting to sexual relations.
Well, surely it must be implicit in the court's exercise of discretion that it will examine the lawfulness.
Well, my lady, I've produced the appendix which sets out the identification. My lady has it, thank you. The identification of relevant information. And you can see, in I think of what is a fairly complete list, that Pease Partners' consent has been rejected clearly twice, once by Mr Justice Mostyn, once by Mrs Justice Parker. And despite the inquisitorial nature of the Court of Protection, the judges at first instance, and indeed in two Court of Appeal decisions, have not felt the need to spell out the inclusion of that. And that, we say, is because the Court is right to be clear that Section 27 has indicated the matter is consent to sexual relations. And Mr Justice Hayden makes that very clear. Perhaps if I can ask the Court to turn to 1251 and go back to Tower Hamlets and NB, 1251, and ask the Court please to read paragraph 34.
That's perfectly straightforward, isn't it? The court doesn't have that ability to make that decision on behalf of an individual. And, but that's just, still doesn't define the matter in Section 2.
My Lord, I've made the submission that the short answer is Section 27.
Yes.
Meeting some judicial resistance, I'll go to the longer answer, which is set out in the Court of Appeals, we say, erroneous reasoning. And perhaps I can ask my Lords and my Ladies to turn to page 247, the judgment of Lord Justice Baker, in the court below. page 247, and I'm looking at paragraph 91. We say, if one looks at paragraph 91, whilst the court obviously rightly begins with City of York, it doesn't go on to define the decision in respect of the matter. It says at 91, what is the decision in question? Well, we say that's actually not quite right. It is, what is the decision in relation to the matter for P himself, herself. And then at paragraph...
What is the decision then? If you say that the matter is consenting to sexual relations, what's the decision then?
To give or withhold consent to sexual relations.
Purely one-sided. Purely one-sided. Ignoring the other side. Yeah. So with the potential of committing a criminal offence.
The court, at the low-level test for consenting to sexual relations, is concerned with the nature and character of the act, not the lawfulness of the act.
What does the local authority do after you've given ability to have sexual activity with people and the patient doesn't understand that the other person has to consent? Well, what's the local authority supposed to do then?
Well, there's two clear options, my lord. There is a discussion with the local chief constable to consider an application for one of the range of protective measures set out by Parliament in the Sexual Offences Act, Sexual Harm Prevention Order, if there's been a conviction, or if there's no conviction.
And what would that order actually say, the SRO actually say, that would be understood by the patient if he couldn't understand the concept of consent?
Well, the order could be very simple. You must not be alone with a woman.
So the criminal courts would have that jurisdiction, but the Court for Protection wouldn't.
Yes, yes, my lord. The Court of Protection also has measures to restrict contact, even when somebody has capacity to consent to sexual relations. Mr. Justice Baker, in a case called A Local Authority in TZ number 2, and that's in the bundle, sets out how that works. It's not straightforward, but it is possible, my lord.
And those people who care for P would lose control of the proceedings because they would be in the criminal courts being conducted by what, a chief constable, and the patient would be criminalised if he broke the order.
If he broke the terms of the SRO, it's a criminal offence, my lord, yes.
And so the official solicitor wishes that path to be followed.
Well, the official solicitor says the appropriate way to approach this very complex area is that the Court of Protection and the Mental Capacity Act have certain functions, and the criminal justice system and the protective orders in the Sexual Offences Act have another function. And Parliament has provided safeguards in respect of the Sexual Offences Act, right to vary the order, rights to appeal, the sexual act which gives rise to the SRO must be proved to the criminal standard. That doesn't collapse my client's procedural rights in the way that, to some extent, could be considered to have happened here, that he leads a highly restricted life because of the local authority's concerns. But if there are concerns, procedural protection to him suggests, and Parliament makes clear through the use of SROs, that the application is one in the Magistrates' Court to the criminal standard.
So if he's likely to commit a criminal offence, you wouldn't get an SRO?
I will, when I get to Section 7, my lord, will take my lord and my ladies to the Home Office guidance and a divisional court decision that shows that the Sexual Act test is a very low one, and without trying to paraphrase the case law, says something along the lines of a sexual act can include, for example, communicating with somebody in a sexual way with the purpose of trying to meet them. So it is a relatively low threshold, and that is how Parliament has set out the risks to the public.
But by virtue of the fact that it has to be proved beyond doubt, a patient who probably will commit a sexual act will not be the subject of an SRO.
My lord, I'm respectfully not sure that that's right. If someone is engaged in the steps which run up to committing a sexual act, for example, texting people or sending inappropriate images, making phone calls, then those, as I understand the Home Office guidance and the case law, can amount to a sexual act which, proven to the criminal standard, can then result in a sexual risk order with very simple language. So, we say, when you consider the respondent's case, that, well, my client doesn't understand capacity to have contact with others, but that's a relatively complex issue. Being told in straightforward terms, you must not be on your own with a woman, that's a matter to probably and must be considered on evidence, but we say is achievable.
Can I make it absolutely understand clearly? In this case, JB, unfortunately, cannot understand that other people have to consent, and I think that's a given in this case, isn't that right? And so you are saying, in such circumstances, the appropriate course is for an SRO to be given, to be made, preventing from having contact with women.
That is one of the range of legislative options. The SRO has been determined by Parliament to deal with questions of sexual risk.
But I was trying to bring it down to the facts of this case.
Well, these proceedings are ongoing, my Lord, and the local authority have not explained in evidence or sought evidence from the local chief constable as to why there hasn't been consideration of an SRO. So I'm loath to go into the detail of that for obvious reasons, but what we say is there are two different legislative schemes with different purposes. The Court of Protection and the Mental Capacity Act aren't concerned with public protection. The sexual offences in the criminal courts are. Returning then to my section 2, which is the long answer to why it's consent to sexual relations, and that I ask the Court please to look at paragraph 93 of the decision of the Court of Appeal. Uh, 247 on the e-bundle. And this is an argument we develop at paragraph 16 of our written case, which is pages e-bundle 71 to 72. But the last three lines of 93, we say, are incorrect reasoning. It says, in the present case, it's JB who wishes to initiate sexual relations with women. The capacity in issue in the present case is therefore JB's capacity to decide to engage in sexual relations. In my judgment, this is how the question of capacity with regard to sexual relations should normally be assessed in most cases. First, we say that the evidence doesn't support that bold statement. And secondly, a wish...
It doesn't support that he wishes to initiate sexual relations with women.
Well, he wishes to have a relationship or sexual relations with particular women, the lady.
Who haven't been identified.
No, Lord.
So therefore, generally with women.
But the predicate for that part of paragraph 93, which you're criticising, is the sentence, the word consent implies agreeing to sexual relations proposed by someone else. Do you challenge that?
We do challenge that, my Lord, because we simply say it's really unworkable in practice to be able to determine who proposes sex and who agrees. There will be many, many cases where it's simply just not clear. There may be cases where it's obvious and clear. Obviously, we understand that. But this separation, to have two different decisions, capacity to consent and capacity to engage, because the Court of Appeal isn't discarding capacity to consent, it says there's two different decisions, we say is just not workable in practice. It would be very difficult to work on that, and it would require two different tests in respect of P. So is it the case that JB has to be the subject of a test for capacity to engage in sexual relations and the subject of a test to consent to sexual relations? So we simply say that that's unworkable. We also say that description of a wish to initiate sexual relations is in reality not a decision for the purposes of Section 2 and 3. That is simply a desire. And
he has that desire, and when he meets a young woman, then he has to take a decision whether to engage, whether to take the steps that he hopes will result in having sex with her. That's the decision that he's facing. And that's the decision that the Court of Protection has to decide. Does he have capacity to use and weigh up the information that's relevant to enable him to take that decision? Don't you have to look at the decisions that the patient wants to take, says that he wants to take? Isn't that part of respecting his autonomy? Doesn't seem to be a problem here with him being able to choose which woman he wants to pursue. He can choose that he can approach some women and not others, depending on what he finds attractive. That's not the problem. The problem, or the decision he has to take, is whether to pursue the particular woman, isn't it?
well, the matter is, does he have capacity to consent to sexual relations? And we say that doesn't depend on the characteristics of any proposed sexual partner. Does he understand the sexual nature and mechanics of the act, that there are sexual health risks, that pregnancy is a potential outcome, and that he has a choice? That is his understanding. And if he understands that and has capacity, he then can provide his consent to a particular person. But
What's the difference between sexual health outcome, potentially adverse, and the consequence that he might be committing an offence, which may injure another person?
the latter goes to the lawfulness of the decision, lady, not its essential character.
But why is it just a question of lawfulness? Why is not the risk that a particular decision to engage with a particular woman may cause her the most grievous long-term and possibly irreparable harm if she doesn't consent, not of itself, and regardless of criminal sanction, a matter which goes to the decision?
The construction, which may not be receiving as much traction as we would hope for, is that...
We're just testing it, Mr. McKenzie.
My Lord, absolutely. My Lord, the decision is whether or not to provide P's consent. That is a decision they make for themselves in respect of the low-level sexual nature of the sexual act. The longer-term consequences aren't part of the relevant information for those purposes. And
so, I mean, I'm just trying to get my mind around that. So, if you were a capacitous person, would you wish to take into account the long-term consequences for the other person? And then why are you depriving a potentially incapacitous person from taking into account that information? Isn't that just an ordinary feature of everyday life, that you do not wish to cause grievous injuries to other people? And why are you preventing a patient from the privilege of having that as part of his understanding?
My Lord, there's a distinction between having the capacity and exercising it. And it's not possible to identify the relevant information by reference to what the capacitors do. We know that capacitous people make unwise decisions, commit crimes. The exercise of capacity can lead to extremely serious results for both parties. But there's a distinction to be drawn between having that capacity and understanding the nature of the act and then exercising it. And that's not to say that P shouldn't be protected. As we say, there are provisions regarding restrictions on contact and solutions in the Sexual Offences Act, which are the appropriate way to do it. But the low-level test, which has been the law for 10 years, remains the essential information that P must understand to exercise their capacity to consent for themselves to sexual relations. The second part of that, of the argument in section 2, is that the matter is an issue-specific one and not sexual relations with a particular person. And perhaps I can ask the Court, please, to turn to the decision of Mr. Justice Mumby in Re MM 2007 EWHC 2003 at page 1500 of the bundle. This was an inherent jurisdiction case from 2007. And the paragraph I ask my Lord, my Lady to read is paragraph 87 on page 1523. So paragraph 87 at 1523. And we say that reasoning is correct. It does not depend on an understanding of the consequence of sexual intercourse with a particular person. It is an issue-specific decision. And that approach was accepted by the Court of Appeal in the matter of M, an adult capacity to consent to sexual relations, 2014 EWCA Civil 37, which begins at 1472, please. This is obviously one of the leading authorities on consent to sexual relations from the Court of Appeal from 2014. And if I can ask my Lord, my Lady to look at paragraphs 76 and 77 at 1496. And we read that as...
I can see why that may be so in many cases, and in particular this case, because the predicament is that your client wishes, if possible, to engage in a normal adult sexual relationship with someone who doesn't yet know who. And the question is whether he has capacity to make the decisions which that process of finding the someone and engaging with that someone will involve. But why should this be invariably true? Because the Court of Protection may be, and has on the authorities, been presented with cases where the question is whether a couple who've been married for 25 years, whether it's right that one of the spouses can go on having the capacity, has the capacity to go on consenting to intercourse with her spouse, which they've been doing for many years, which raises a highly person-specific question and might produce a different answer than one that one would come to on the facts of this case. And why does one have to be so dogmatic about whether it's general or not general? General or specific, whether it's person-specific or not?
Well, there is a flexibility in the dogmatism, my lord, inasmuch as the courts have recognised that the list of relevant information can be tailored. For example, in the case of TZ, Mr Justice Baker accepted, for example, that pregnancy for same-sex couples was not part of the relevant information. Mr Justice Hayden, in the NB case, took the view that with a monogamous long-term relationship, married couple, where there hadn't been a history of STIs, that was potentially not relevant information either. So there is a flexible approach to the relevant information in the case law, my lord, which we say is right, but there are some core requirements which set out in that non-person specific way, without assessing the consequences of sex with a particular person, there is relevant information which goes to whether or not the person has that capacity or not. And that shouldn't or cannot change given P's partner's sexual identity.
Going to paragraph 77, it may be that many people would pass the test of capacity that has been set out by the Court of Appeal. And so all those cases would be out of the way. Those people who failed might pass the test in relation to a particular individual, because the particular individual might have capacity. So they wouldn't have to understand, the patient wouldn't have to understand that the particular individual has to have capacity, if in fact the particular individual does have capacity.
Well,
it would be depriving the patient of a sexual relationship if the only thing he failed on was a failure to understand capacity, and he was proposing a sexual relationship with an individual who had capacity, and surely you would take that into account.
Well, obviously, we would say that the entire issue of P's partner's capacity is not relevant information that comes back to the Section 2 decision in respect of the matter. The extent to which, whatever this court determines is the relevant information, and the extent to which it can be flexibly applied, will obviously depend on what the relevant information the court says is appropriate. But we maintain our view that it has to be at a low-level one. And my Lords, my Ladies may have seen the case of HD, a decision of Mr Justice Cobb, where the very issue of the complexity of understanding sexual partners' capacity in the abstract was the only reason which prevented HD from having capacity to consent to sexual relations. So the historic and traditional view, we say consistent with the language of Section 2, is that
Why has the common law view under the inherent jurisdiction got any relevance at all to the Act, which sets out very simple tests? Why do we always stretch back into the inherent jurisdiction in order to find the test, as opposed to just looking at the statute, saying that's the test?
My Lord, to some extent the answer is that in either MM or MB, you'll have to recall that Mr Justice Mumby was aware that the Mental Capacity Act was on the statute book, and he said that the test he set out of the basic information was entirely consistent with an analysis seen through the lens of Section 3 of the Mental Capacity Act. And that obviously has been influential, because my Lords, my Lady will have seen almost every judge of the Court of Protection has in one form or other applied that test. The common law is important, my Lord, because we say whether you have capacity to consent to sexual relations cannot vary on the basis of whether it's being forensically considered in the civil context or the criminal context. One either has capacity or one doesn't. And Mr Justice Mumby develops capacity to consent to sexual relations from the criminal case law, and particularly the Australian case of the Crown and Morgan. And my Lord, my ladies will have seen from the written case, without turning it up just now, there is a note in the Law Commission's consultation paper looking at consent to sexual relations, and the consultation paper uses the language consent to sexual relations and references a criminal case to set out the test. So the common law, criminal law, has had an influence on the Law Commission and the wording of the Mental Capacity Act. That's why it still continues to have importance.
Where is the reference to the Law Commission's consultation document?
My lady, it is at page 3433. It begins at 3433, my lady, and the paragraph number I rely on is 2.27 at 3478. And perhaps it's worth briefly turning it up.
Kendrick, I'm acutely conscious that we're messing up your timetable good and proper. We'll try and let you have your head a little. But no doubt you'll want to focus in your further oral time on matters where you really want to add something to what's in your written case.
My Lord, absolutely. Just in terms of when the clock stops, from my perspective, given our short IT issue, is it still around the 12:30, 12:45 mark?
Well, I think it's going to have to be nearer the 12:45 end than the 12:30 end. Faute de mieux, we do have to end at 4 o'clock.
Lord, yes.
And that's something we can't really avoid.
I understand. Thank you very much. Well,
We may trim 2.5 minutes off your opponent just to make it fair on both sides.
I would feel a lot better about that, my Lord, yes. The Law Commission's consultation paper is at 3478, and paragraph 2.27 deals with the consultation in respect of capacity to consent to sexual relations, and it says, in the general, follows the usual form that the person concerned must be capable of understanding what is proposed and its implications and exercising choice. And Aaron Howard, which is in the bundle, is footnoted at 73. That criminal law test has been developed somewhat. There's an Australian case called Aaron Morgan, and if I have time, I'll go to a very recent Canadian case. But that's important, my Lord, because the criminal law has influenced the civil law in respect of what it means to have capacity to consent to sexual relations, and that influenced the Law Commission and ultimately the Mental Capacity Act.
It wasn't saying that the two are mirrors, it's simply giving an example of when there would be no capacity.
My Lady, I would accept that, yes. Turning then to my section 3, what is the relevant information? And coming back to the Court of Appeal's decision, if we may, which is at 247. The thrust of what we say is paragraph 91 and following misidentifies the relevant information because it focuses on a decision that the capacitist would normally have or make. And that disconnects the relevant information in respect of the decision, in respect of the matter, and doesn't apply what Lord Justice McFarlane calls the core determinative provision of section 2.1. The criminal case law, which I've discussed, sets out some of the relevant information, and it is useful to look at R and Morgan, which is at 1784 of the bundle. Case of R and Morgan from the Supreme Court of Victoria in Australia. And at the top of 1789, you can see a description. It appears to us to follow from these statements of authority that where capacity to consent is an issue, in order to establish that the girl does not have that capacity and there is accordingly no consent, it must be proved that she has not sufficient knowledge or understanding to comprehend A, that what is proposed to be done in the physical fact of penetration of her body by the male organ, or if that's not proved, B, that the act of penetration proposed is one of sexual connection as distinct from an act of a totally different character. And a little further down, accordingly, if the prosecutrix has knowledge or understanding of what the act comprises, i.e. the fact of penetration of its character and the sense above mentioned, then she has all that the law requires for capacity to consent. The knowledge or understanding need not, of course, be a complete or sophisticated one. It's enough that she had sufficient rudimentary knowledge of what the act comprises and its character to enable to decide whether to give or withhold consent. That, in turn, influences Mr. Justice Mumby in ex-City Council and MB. And if I could ask the Court to go to 1568. And really the relevant paragraphs are 65 to 75, but the only paragraph I ask my Lords and my Ladies to read is paragraph 74. Now, we would add to that P has a choice, because that's more consistent with the language of Section 3, but that the issue of giving or withholding consent to sexual relations must necessarily involve a limited amount of relevant information, because it is the sexual act in general and not the reasonable foreseeable consequences of a sexual act with a particular person. If it's a sexual act with a particular person, then there are further consequences. But that has not been the formulation pre-common law or by the judges of the Court of Protection as set out in our appendix. Considering Section 3.4, the reasonable foreseeable consequences, if the decision in relation to the matter for P is whether or not to give or withhold his consent, then P's partner consent is not, on that test, information relevant to P's decision for himself or herself to give or withhold his or her consent. P's decision is not related to A's consent. And the language of the Mental Capacity Act, certainly in respect to Section 27(1)(b), talks about consent to sexual relations, again for reasons that I've explained as set out in the background by Mr. Justice Mumby in earlier decisions. And if there are reasonable foreseeable consequences of deciding one way or the other, consistent with the language of the Act, P cannot unilaterally decide one way or the other to have sex with somebody. The only decision that P can make is whether he or she consents to have relations with them. there is in reality no weighing up of information if P's partner does not consent.
I don't understand what you mean by saying P cannot unilaterally decide whether to have sex with someone. Isn't that the problem, that P can decide unilaterally to have sex with someone? And the question is whether this P is able to weigh up the information in order to take that unilateral decision.
The decision must be seen in the context of sections 2 and 3, particularly section 2, and if the decision in relation to the matter is giving or withholding his or her consent to sexual relations, then that, we say, limits the relevant information which must apply. And without turning it up, that is certainly the logic endorsed by Mr Justice Mostyn in the decision of D, Borough Council and B, 2011 EWHC 101 Family, which is at 1209. I don't think there's really time to turn it up, but I'd ask my lords and my ladies to read paragraphs 39 to 41 at 1222. Mr Justice Mostyn's thinking evolves in the case of Tower Hamlets and TB, which is in paragraph 41, which is at 1292 of the e-bundle, but he doesn't again take the view that P's partner's consent is relevant information.
Sorry, page again?
1292, my lady, paragraph 41. That's also the view of Mrs Justice Parker in Southwark and KA, neutral citation 2016 EWHE 661 FAM, which begins at 1224, and we rely on paragraphs 54 to 56 at page 1234. And the relatively low level of the information required is supported, we say, by Baroness Hale in the case of R and Cooper. And perhaps I could just ask the Court to quickly look at page e-bundle number 1440.
Sorry, the page number, sorry.
1440, my lord.
Thank you.
And just a short quotation, at paragraph 15, this adopted essentially the same functional approach as had the earlier report on mental incapacity, but using simplified language more apt to describe the process of deciding consent to sexual activity, as opposed to deciding upon a course of conduct with civil legal consequences. Essentially, this is because it's perceived to be a visceral rather than a cerebral process of decision-making. Quite so. And again, that to some extent draws the distinction between the essential nature of the Act, which is the traditional test for capacity to consent to sexual relations as seen against a low level of relevant information, as opposed to courses of conduct with civil legal consequences, which would be different.
She was in fact a member of that Law Commission.
My Lord, yes.
Yeah.
It was very much her work, the mental capacity.
Absolutely, my lady, yes.
My Lord Burrows was there at the time, so
Yes,
he might be able to help.
I can confirm it was largely the work of Lady Hale.
Thank you, my Lord.
Thank you.
There is a dearth of case law, we say, in which the relevant information tackles the question of whether or not action or inaction by P amounts to breaking the law. And it's my understanding from the Respondent's case that they really only rely on one case, which is B&A Local Authority 2019 EWCA Civ 913, which begins on page 1046. And if I could ask the Court to look at the consideration of social media information which is set out in the judgment from Mr Justice Cobb at paragraph 40, you can see it. If you look at or share extremely rude or offensive images, messages or videos online, you may get into trouble with the police because you may have committed a crime. The Court of Appeal doesn't disagree necessarily with that formulation at paragraphs 43 and 44. But we say that Mrs Justice Roberts, at first instance, provided a convincing reason why that does not read across to the question of capacity to consent to sexual relations, and that's at page 283. At paragraph 77, this is the judgment of Mrs Justice Roberts for first instance in these proceedings. And at paragraph 77, she essentially distinguishes the fundamental nature of a decision to use the internet from one to engage in sexual relations. And we say her analysis at paragraph 77 is right when you're considering what is the relevant information for the purposes of consent to sexual relations. That is the correct approach. Turning then to the still considering issues of relevant information, I don't have time, I think, to ask the Court to turn it up, but the inclusion at paragraph 103b by the Court of Appeal of...
If you're saying paragraph 77 that you've got to only look at visceral rather than cerebral information, why is the fact that the woman might get pregnant or might give you a sexually transmitted disease more visceral, and the fact that she might not be consenting and you might therefore be doing her considerable harm cerebral?
The cerebral nature is there because the Court of Appeal, to adequately describe consent, have to set it out as they do at paragraph 103b of the decision, that in fact peace partner has capacity and consents to sexual relations at the start and throughout. That is a complex analysis, my lady. There are lots of different reasons why consent can be vitiated, and to require P to understand, retain, weigh up and use an abstract P's capacity is a very difficult thing. And indeed, for a large part of the last 10 years, judges of the Court of Protection have spent days trying to resolve whether P does or doesn't have capacity to consent to sexual relations, and we accept AP, my client, isn't conducting a written capacity assessment, but nonetheless, the effect of section 103b of the Court of Appeal's decision is to require him to understand, retain, weigh up and use information that a potential partner has capacity. And that, we say, is cerebral, goes into issues of the lawfulness of the decision rather than the character of the decision. And you can see that illustrated, my lords, my lady, in Mr Justice Cobb's decision of HD. I'm not asking the Court to turn it up, but it's 2021 EW Cop 15 at page 1447. 1447. And I would ask the Court to read paragraphs 24 to 27 at 1455. But as I say, I don't ask you to turn it up at this stage.
Can I just be clear what you're saying here? Are you saying that I think everybody's accepting, a lot of your submissions seem to me to be that was the law. I think everybody's now accepting it was a move by the Court of Appeal to a new position. I've not heard much other than, well, that was the law, and that was the law, and that was the law. But nevertheless, the question I think I'm concerned about, which you're just touching on, is if we assume that the Court of Appeal was in principle correct, that one should move to considering the consent of the partner, that is, consent to engage in sexual relations rather than just capacity to consent. Are you saying it's impossible to devise a test that is workable, that doesn't involve too much complexity? Or is it open to us to accept the move that the Court of Appeal has made, but to think perhaps more carefully about how one precisely phrases the question that should be asked?
My Lord, to try and answer that question directly, if the relevant information were not to include 103B, but a formulation along the lines of P must understand that the sexual nature of the act involves the consensual nature of the act, then that is a lower level test that would have less consequences for the category of, for my client and the category of people like him. The challenge, though, is that if one reduces it to the act is consensual, what does that mean? And it is quite difficult, we say, not to have spelt out capacity to consent and consent at the beginning and throughout, because that's what consensual means. So it's very difficult to have a more nuanced test, a less abstract test.
Well, what about the test that's proposed by the intervener, Respond, which distinguishes between consent and capacity?
It is, my lady, yes, more attractive from our perspective, but it runs into something of a difficulty in that there wouldn't be true consent if P's partner lacks capacity to provide it. And once one starts going down that road, it's one of the great challenges. There could be intoxication, there could be mental disorder, there could be other reasons to rob P's partner of capacity. And then there's the host of reasons why consent may in fact be lacking. And we've put into the supplementary bundle of authority, supplementary bundle, the Crown Court Compendium, which sets out different ways in which consent be vitiated, and it's complex and very difficult. So if the court were to be against my position and say, well, it is capacity to engage, we have moved on, that's consistent with sections 2 and 3 and section 27, then yes, we would welcome something less than 103B, but we have to acknowledge that when you import consent, it comes with quite a lot of information. The reference for the Crown Court Compendium is supplementary bundle at D20, where it begins, and we rely on paragraph 17 at D23, which sets out in a straightforward way, and obviously in the Crown Court Compendium, how consent should be looked at. So our submission on the relevant information, consistently with the language of the Act, and is that there are 4 pieces of relevant information. the mechanics and sexual nature of sexual relations, that P has a choice and can say no, that there are health risks involved and precautions can be taken against those risks, and at least for heterosexual couples, sexual relations may lead to pregnancy. And we say on that test, JB would have capacity, and we say that that's clear in the evidence at 636 of the bundle. Turning then to section 4, I shall, I think, fairly briefly outline why we say an Aaron Cooper person-specific approach couldn't work and is not consistent with the language. The first point that we would make under that section is that there simply isn't any evidence filed by the respondent about the evidence it would require, how it would be applied in practice, identification of sexual partners, and how one would go about taking account of their characteristics, the consent process for that, the decision-making process to assess JB's partner's characteristics, to assess whether he has capacity. What would that look like? How could he challenge it? Therefore, without any evidential background and without a first instance judge looking at the evidence and it being challenged, it's extremely difficult for this court to consider applying a test of that nature. And the second point is the point I've already made, that P either has capacity to consent to the sexual act or not, and it cannot differentiate on the basis of P's partner's circumstances consistently with the language of the Act. The point made against the person-specific approach is set out by the Court of Appeal in the case of M, and we've been to it, but it's page 1496. At paragraph 77, probably no need to turn it up because we've just been there, but they go as far as saying it's totally unworkable for a local authority or the court of protection to conduct an assessment every time an individual over who there was doubt about his or her capacity to consent to sexual relations shows signs of immediate interest in experiencing a sexual encounter with another person. We also say it would be profoundly invasive of P's rights to a private life to consider their capacity against each actual or proposed sexual partner. And it's also important to note at the bottom of 1499 that permission to appeal the decision in which the Court of Appeal creates the bridge between what I call the traditional test and what Baroness Hale said in Aaron Cooper was in fact refused by a panel which included Baroness Hale.
But as I have heard other members of the court say, one should not assume that that's an approval by the court.
Milady, yeah, I accept that.
I have Baroness Hale's words, "We are not a court of error," ringing loudly in my ears.
The same logic we say applies in respect of capacity, goes back to my Lord's point regarding Sheffield and E, but one can see at paragraph 85 on page 2732 of Mr Justice Mumby's decision in Sheffield and E, 2732, paragraph 85, powerful reasons why one is concerned with the nature and the contract of the marriage and not the characteristics of a particular spouse or intended spouse. And again, we say that that logic is correct and would apply with the same difficulties in respect of capacity to consent to sexual relations if it were to be person-specific.
But if we've got a situation where we have a clear person in mind, I'm just looking at your paragraphs 118 and in fact 121, you refer to the DY case and we're talking about the current partner. Difficulty with the abstract concept of a different partner, but with the current partner there's no difficulty. Now, isn't that an example where a person-specific approach would seem appropriate?
It may be a case, my Lord, for tailoring the relevant information, but it would, in our submission, not be right to say that the exercise of the capacity only relates to one person and their characteristics.
Well, I think that's just words, isn't it? Tailored to the specific, i.e. tailored to this person.
Yes.
So you are accepting that that is an acceptable approach?
No, my Lord, I'm not accepting that, no. What I would say is that if there were circumstances in respect of P's circumstances, which are brought about by their relationship with A, that might be a reason to tailor or reduce the relevant information, but it would still be an issue or matter-specific approach.
Still be an issue of what, sorry?
An issue or matter-specific approach, my Lord. Not a person-specific approach.
Well, you've just tailored it by virtue of the fact it's a person, an identified person.
P's characteristics, my Lord, not P's partner's characteristics.
Well, pregnancy wouldn't arise if the person's infertile.
Yes, my Lord, that's something that Mr Justice Mostyn considers in Tower Hamlets and Mr Justice Hayne considers.
So the relevant information depends upon the person?
Well, it depends upon the reasonable foreseeable consequences for P that they are partners infertile. So it's consequences for P that you could tailor the relevant information. Still, we say it doesn't make it a person-specific approach.
But isn't it a question of identifying the decision that you're looking at whether P has the capacity to take? And in the case where what you're looking at is whether someone has capacity to consent to sex with their husband of 25 years, that's arguably a different decision from a decision to go out and find a woman to have sex with. Or a number of women to have sex with.
Well, the deployment of consent is specific to the person, but the matter, the capacity, we say would still exist or not. It's a low-level test. If one understands the sexual nature of sexual relations in general, then it would be surprising if capacity could change from one scenario to another. And the last point in respect of R and Cooper is the decision of Mr Justice Mostyn, going back to Deborough Council. I've lost the e-bundle, but it's paragraph 18 of his decision, the first decision in the Court of Protection, where he makes the point in respect of Gillick competency that the House of Lords didn't need to take the view that the under-16s be considered in Gillick. The doctor wouldn't need to know the sexual partner of the child, because capacity to consent to sexual relations is issue-specific rather than subject to the identification of P's partner. It is almost 12:30, and I have still some way to go.
Yes, well, you can certainly have until 1:45, Mr McKendrick.
Thank you very much.
That will cut into your reply, but I will dock off just a little bit of Mr Sachdever to give you slightly more than the bare minimum reply.
My Lord, that takes us to issues of the criminal law, which I will have to take pretty quickly. The overarching point, we say, is that it's not helpful to protect the autonomy of complainants in sexual offences cases, or P's autonomy under the MCA, that they would be a JB-style test and a test for the complainant's capacity in criminal cases. The criminal law has sought to maintain, until most recently, and I'm going to take my lord and my lady to a Supreme Court of Canada case, the traditional position, and it's possibly worth turning that up just now, is the case of R&GF Supreme Court of Canada case, which is at 4156.
Did you say 1456?
It is 4156, my
I'm
lord.
so sorry, thank you.
And one can see on that opening page, Supreme Court of Canada, and the paragraphs in which the majority decision, which is set out by Justice Parakatasanis, is set out at 4192, please. And you can see paragraph 57, I hope. Obviously, this is in the criminal context in Canada, but in sum, for a complainant to be capable of providing subjective consent to sexual activity, they must be capable of understanding four things: the physical act, that the act is sexual in nature, the specific identity of the complainant's partner or partners, and that they have the choice to refuse to participate in the sexual activity. A complainant will only be capable of providing subjective consent if they are capable of understanding all four factors. If the crime proves the absence of any single factor beyond a reasonable doubt, then the complainant is incapable of subjective consent, and the absence of consent established at the actus reus stage. So, this very recent 2021 decision, again, we say, sets out the appropriate level of relevant information and is essentially consistent with the common law test, which applies in respect of the initial offences under the Sexual Offences Act. There is a separate test for capacity in respect of the Section 30 and following mental disorder tests, which is at 875 of the Sexual Offences Act. Jumping around a bit, I'm sorry. So this is the sexual activity with a person with a mental disorder impeding choice, and that A commits an offence if he intentionally touches another person, the touching is sexual, and B is unable to refuse because of or for a reason related to a mental disorder, and that A knows it could reasonably be expected to know that B is a mental disorder, and that because of it or for a reason related to it, B is likely to be unable to refuse. And then 32 is important. B is unable to refuse if he lacks the capacity to choose whether to agree to the touching, and whether because he lacks sufficient understanding of the nature, reasonable, foreseeable consequence of what's being done, or for any other reason, or he is unable to communicate such a choice to A. Now, the Court of Appeal Criminal Division considered this in a case we set out in a written case called RNAG, decision of Lady Justice McClure. And if I could ask the Court please to go to that at 1384. So, 2014 EWC Crim 299, judgment given by Lady Justice McClure beginning on 1384. You can see that the brief facts at the head note, which I'm going to move on from to paragraphs. Really, the core reasoning is at paragraphs 16 to 28, which begins at page 1388. And perhaps I may just ask the Court to read 16 to 28. So, Lady Justice McCord is summarising the approach of the Court of Appeal in the case we've looked at of IM, and taking the view that the approach to the test for capacity to consent to sexual relations should be the same in the civil and criminal law. Now, we say that reasoning is correct. Of course, it must be applied in a different way. This is the point made in IM. There's a difference in the standard of proof from the civil and criminal, and the focus of the criminal law is on the deployment of capacity at a particular stage historically. The Court of Protection is looking at a forward-looking analysis. But that makes obvious sense because it would be unusual as a matter of logic if someone's capacity changed dependent on the civil or criminal context. Either one does or doesn't have capacity and can exercise it. And the difficulty with the decision of the Court of Appeal in JB is it will create confusion by introducing a different test, if it's upheld, in the civil law. And I don't have time to go through it, but we explain why that will create challenges in the criminal courts at paragraph 48 of our written case, which begins at 83.
In the criminal case, can you even introduce a decision of a High Court judge in the Court of Protection as evidence in the criminal case? The accused isn't a party to that decision, and so presumably you would be, the prosecution would be calling the same witnesses, but they wouldn't be relying upon the decision of the in the civil case. Different standard of proof as well.
Yes, I certainly acknowledge it's a different standard of proof, my Lord. The points we develop at paragraph 48 on 83, I think, set out some of these complications and challenges and difficulties, and it's certainly been, in my experience, that the CPS will seek disclosure of documents from a High Court judge in the Court of Protection to further their case in a trial, and we say it creates difficulties and challenges.
Is a possible distinction between the civil context in the Court of Protection and the criminal context this, that in the criminal context, the defendant to the charge will almost invariably, I can think of one exception, be the initiator, and the complainant will be the person whose consent or capacity to consent is the critical issue in the proceedings. Whereas in some Court of Protection cases, including this one, P wants to be the initiator, and therefore it's really a very different context from that with which the criminal law is generally concerned. I mean, the exception I have in mind may be where an underage, let's say, boy initiates sex with an overage, with an adult, and then, of course, he can't consent, and then there are issues about that. But apart from that exception, it seems to me that might otherwise be a distinction worth thinking about.
My Lord, I can see that. I think it goes back to the point we made earlier, that it's going to be extremely difficult to, in many cases, disentangle engage to and consent to, and it will mean that if there are two, if it's accepted that there are two tests, then P is going to have to be assessed against those two tests, because it can't always be assumed that whether P is a defendant in, say, a criminal trial, that they will always be the person who seeks sexual contact. So you would have to have two different tests, one of capacity to engage in sexual relations and one of capacity to consent to sexual relations, which is going to create confusion and errors and difficulties for the reasons we set out in our written case.
Well, is there any comment in the practitioners' journals about this? Because you're saying this is what practitioners will find difficult. I think criminal lawyers tend to be quite good at sticking to their own case law and not being...
Well, that is part of the, I think, respondent's case. If my lady turns to page 1791, you can see Blackstone's criminal practice and capacity to consent. And I think the point is made against me that 1792 identifies JB and says, well, there isn't really a problem. I think our point is that you look at 179 and 1792, you can see that the editors of Blackstone's do set out what the civil law is, because Lady Justice McClure said it makes sense that the approach should align, even if the standard of proof doesn't. And that creates a simplicity. Multiple tests are going to add to the challenges for both justice systems. So I think that, I hope, answers my lady's question.
Well, I'm getting slightly concerned that we are talking about the capacity of different persons. In the criminal law, you're concerned with both parties' capacity, aren't you?
You're certainly concerned with the complainant's capacity and the reasonable belief of the defendant approaching capacity and consent of the complainant.
But in the COP jurisdiction, it's only the person who is initiating the proceedings. Initiating, or it's only one party anyway.
Yes, it's one party. It's focused on P, and we say P's decision to give a full consent. Given I have 5 minutes before 12:45, I'm going to turn to the question of sexual risk orders. Our written case is set out to paragraphs 65 to 90, which is electronic bundle 88. There's a lot of detail set out there, but if I may, I'm going to ask, please, the Court to look at the case of Commissioner of Metropolitan Police and E-Banks, 2012 EWHC 2368 admin, which is at 2186 of the bundle, please. Begins at 2186 and it's a decision of Lord Justice Aikens and Mr Justice Globe concerning effectively the predecessor to the sexual risk order, the risk of sexual harm order, RSHO, but I don't think very much turns on that for present purposes. But at paragraph 19, Mr Justice Globe sets out his judgment in response to a submission that the criminal standard renders these orders ineffective, and that's at 2192. And I just ask my Lord, my Lady, to read, please, paragraph 19. Now, we see, in it as much as these are the types of concerns that the respondent has in respect of my client, Mr Justice Globe is really encapsulating why a sexual risk order is able to protect the public and also provide protection to the subject of that SRO. It's also important to record, and again it's in our written case, that the current Police Crime Sentencing in Courts Bill, which begins at 1876, has a proposal to make the standard of proof for an SRO the civil standard in respect of the Sexual Act, rather than the criminal standard. And perhaps I can draw my Lord and my Lady's attention to two cases that are in our written case, just to provide you with the references. The essential point made in these two cases is that the criminal justice system is the appropriate forum to deal with questions of sexual risk to the public, and not the family courts. The first is a decision of Mr Justice Hayden called Redbridge and A, which is 2015 EWHC 2140 family, and that's at E-bundle number 2683, inherent jurisdiction case, family case at 2683, And a similar approach is adopted by the Court of Appeal in a criminal case called R&D 2005 EWCA Criminal 2951, which is found at 2503. Questions of capacity of the subject to be made subject of an SRO are considered in the case of R. and Pashley, which is 2015 EWCA Criminal 1540, which is at page 2570 of the e-bundle. They're not specifically in respect of sexual risk disorders, but again, we say the overall approach is appropriate, and we would say that it is the type of measure that can be used to protect the public and is a more effective and appropriate one than tailoring the Section 3 relevant information. We also have a point on Article 8 and the interpretive obligation, but I won't get to that. But you have our written case on that. It's 12:45. If I may just turn my back, my Lord. Unless I can assist further at this stage.
Thank you very much, Mr. McCarrick. I'm sorry we rushed you at the end, but your submissions have been most helpful.
Thank you, my Lord.
Yes, Mr. Secretary.
My Lord, I'm going to make some preliminary remarks after an introduction, and then I'll turn to the facts and the Court of Appeal judgment, and then I'll deal with three discrete areas: the relevant information applying the Mental Capacity Act, the criminal law, and then human rights. So the nature of this appeal, we say, is a familiar approach of the construction of an act, and in particular of Section 3 of the Mental Capacity Act and the partial definition in Section 3.4. The question raised is, does the relevant information where sexual relations are concerned include the fact that the other person can consent and is consenting throughout? That's the question of law for this court. This is the first case in which the issue has arisen where it affected the conclusion on capacity, and that's why it hasn't been ruled upon before. It hasn't had to be ruled upon before. In both the D and B case, the Mostyn case, the patient lacked capacity, and in the KA case, the Parker case, that's the other case which doubted this part of relevant information. It was also not part of the ratio of the decision, but I'll come to those cases. They are covered in the Court of Appeal's judgment. An interim declaration was made at first instance that P had capacity in relation to consent to sexual relations. That was set aside and replaced with an interim declaration of incapacity, and it's been remitted to Mrs. Justice Roberts to decide, applying that test, obviously subject to this appeal, whether P has final capacity in relation to sexual relations. He has been provided with education starting in November 19 from a clinical psychologist. That went on until the 23rd of March 2020. There was unfortunately a break for the pandemic. It wasn't appropriate to conduct virtual psychology sessions, according to psychologists. They have restarted, you'll see from the evidence that was filed for which permission was granted, in late June this year, and they are taking place weekly, and they're aimed at improving his understanding of sexual relationships. So this is an interim position. Now, it's not disputed that P lacks capacity in relation to contact, or that even if the first instance judgment stands, that the local authority is entitled to offer a fairly restrictive care plan requiring one-to-one supervision in the community and two members in certain situations, and the reference to that is EF 313. But the difference, and why it matters, is that although the local authority can make interventions prior to reaching the stage of sexual relations, if P wishes to have sex with someone, the local authority's restrictions must stop at the bedroom door if the first instance decision is upheld. And there would then remain a significant risk, we say, both to JB and to others. And that's why this appeal matters. Now, it's not disputed that the information relevant to the decision includes the following, and this is paragraph 100, subsection 1, and 3 to 5 of the Court of Appeal decision. That's at EF 249. So the sexual nature and character of the act of sexual intercourse, including the mechanics of the act, the fact that P can say yes or no to having sexual relations and is able to decide whether to give or withhold consent, we say that that actually is more important than relevant information. That actually goes to capacity itself, that second point, as the Court of Appeal in Local Authority in B had said. Thirdly, that a reasonably foreseeable consequence of sexual intercourse between a man and a woman is that the woman may become pregnant. And D, that there are health risks involved, particularly the acquisition of sexually transmitted and transmissible infections. And finally, that the risk of STIs can be reduced by precautions such as the use of condoms. So that is not disputed by the appellant as being information relevant to the decision under Section 3 of the Mental Capacity Act. And it's the addition, apparently, and this is one of the odd things about this appeal, that the information at 100 subsection 2 of the Court of Appeal decision that the appellant asserts is very sophisticated and abstract in comparison with the other information, and that it's outside what capacitated people habitually consider when deciding whether to have sex or not. And that's the essential distinction between Mrs. Justice Roberts and the Court of Appeal. That discrete question, is the information at 100 subsection 2 the sort of thing that capacitated people habitually consider when deciding to have sex or not? Mrs. Justice Roberts said, no, it's too abstract and complicated, and many people would struggle with that somehow. And the Court of Appeal's reaction to this is palpable, and although it's considered slightly bad form to comment on the constitution of any particular court, the court is aware that who is sitting in this particular court and their knowledge in this particular area. But apparently, so it's apparently very sophisticated and abstract compared with the other information, which we say is completely incorrect. EF 250, paragraph 10, the nature of the information at 102 is not of a different order to the risk of the other person becoming pregnant or passing a sexually transmitted disease on. In a way, it's more peripheral and harder to, or not necessarily as present in one's mind. If one's looking at the core information that capacitated people way up, if somebody gets pregnant or there is a sexually transmitted infection, that tends to occur sometime after the event itself, and it may or may not be serious or significant. But on any view, if the other person isn't consenting, that is an immediate thing. It can result in immediate consequences, both in terms of the criminal law, well, upset to the other person, devastating, potentially lifelong upset to the other person. It can result in police investigation, prosecution, and it can also result in action from third parties who are very aggrieved at it. And it's both immediate and potentially very significant. And it's very surprising that the appellant could make that submission, although it hasn't been, I don't think, repeated orally before this court. But that was the difference, essentially, between the first instance decision and the Court of Appeal. So they're saying it's outside what capacitated people habitually consider. They're also saying that it changes the criminal law standard of capacity. Well, I will turn to that, but the short answer to that is the criminal law has its own statutory definitions in this area. The Sexual Offences Act has two types of offences, and it's section 1 to 4, which refers to section, I think, 74, which actually doesn't define capacity. It leaves the question as one for the jury, but it certainly doesn't incorporate the civil law test in the Mental Capacity Act. And the Mental Capacity Act itself makes it clear that the principles, and we'll look at that in a minute, apply only for the purposes of this Act. So you would need an express statutory reference in those criminal statutes to the civil standard if one were able to make a plausible case that a change in the civil standard for capacity automatically translates into a change in the criminal standard. And Blackstone civil practice certainly don't think that that is the case. And with respect, we'll go to the RAG case. The Court of Appeal were under rather a fundamental misunderstanding as to the jurisprudence they were relying on that they thought said that the civil and criminal tests were identical. They weren't saying that. They've never been identical, and they aren't identical. But I'll go through that briefly this afternoon. So the human rights angle, just to summarise that in advance, is that the appellant says that this addition of 100 subsection 2 would somehow elevate the test into one that breached JB's Article 8 rights. We say, in essence, that the opposite is actually true. There is a positive duty on public authorities to protect those who may suffer interference with their Article 3 and Article 8 rights, and how a state carries that positive duty out is well within the margin of appreciation of a state, and the United Kingdom is entitled to partly discharge its obligations under Articles 3 and 8 by having civil law of this sort. That's essentially a summary of our position on the criminal law. So, but coming back to the key issue in this case is very discrete. It is the question of judgment, whether the other party's ability to consent and their continuing factual consent are issues that capacitated people regularly consider or should consider when deciding whether to have sexual relations. That's the discrete issue raised by proper process of statutory construction. So I'm just going to make a few preliminary remarks before we rise for lunch, if I may. The first is that one must apply the Mental Capacity Act without superimposing any glosses. And it is not necessary or desirable to make reference to jurisprudence under the inherent jurisdiction, which is notoriously uncertain and has been replaced by a statute. And the question under Section 3 is, what is the information relevant to the decision? And there are two things that determine the information relevant to the decision. First of all, the nature and character of the act. So you need to know about the mechanics. And secondly, the reasonably foreseeable consequences of deciding one way or another, that's Section 3.4, or failing to make a decision, subject to, and this is the gloss put in the Re-M case approved in Re-B and also in the Court of Appeal in this case, to such consequences not being divorced from everyday decision-making. And all I would say about the origin of the jurisprudence in this area is that it's come from the MB and MM cases, they're inherent jurisdiction cases, and they were both dicta from a first instance judge who assumes, first of all, that marriage is something called act-specific, and so is sexual relations. And I'll go into what that might mean. It basically involves not reading the statute properly. Once you start inventing categories of act-specific and person-specific, and Lord Justice Macfarlane didn't like it in the York case, and ironically, everyone accepts that York is right, but they then go off in their own direction and say, well, some cases under the inherent jurisdiction said you've got to have a very low standard, and that's why we're going to call it act-specific. You get into incoherence that way. We need the Supreme Court to clarify the law. You have seen how difficult to interpret the first instance cases are as a result. My next point is that we say that the other person's ability to consent construed in a non-technical way and their continuing factual consent passes both tests. It's part of the nature and character of the act being fundamentally consensual, and secondly, the reasonably foreseeable consequences are not, as Lady Arden has pointed out already, restricted to consequences 2p. They are consequences, full stop. They are perfectly capable of applying to consequences in relation to people other than P. The statute would have said so if there were consequences just directly bearing on P, because even if it was limited to P, these would be consequences that are indirectly visited on P. Because if he is then prosecuted, that is still a potential consequence on him. So this test, and it's simply explained at 106 in the Court of Appeal judgment, and we'll look at that in a workable fashion, we say, where Lord Justice Baker says, what is needed, in my view, is an understanding that you should only have sex with someone who is able to consent and gives and maintains consent throughout. That's a perfectly workable test, where you understand that ability to consent means that you're apparently of an age to consent, so apparently 16, and not obviously in a physical state where you're not able to consent, unconscious or asleep. This is a non-technical test, but it's an important one. But we say that the relevant information, section 100 subsection 2, passes under both tests of section 3, i.e. the nature and character and the reasonably foreseeable consequences. I don't know if that's a convenient moment. I have, I think, 3 more preliminary points, but I'm in the court's hands as to where you would wish me to draw a line.
Well, you could probably grab at least 1 or 2 of them.
Okay, yes, let me just quickly brush through them. So we say it is consistent, in fact, on the criminal point, with the legal policy which criminalises sex acts performed without consent, subject to a reasonable belief defence, for incapacity law to include the need for the other person to consent as relevant information. Far from conflicting with the criminal law, it's actually consistent with the legal principle underlying criminal law. I've already said the next point, I think, reference to act-specific and person-specific decisions can obscure the main question, which is what is, under the statute, the information relevant to the decision. That's precisely what was said in the York case, and it's, in my submission, correct. Whether the concept is of engaging in sexual relations, which captures the active nature of the conduct, or consenting to sexual relations, in truth is of peripheral importance to the content of the relevant information. It doesn't affect what the relevant information is under Section 3, nor would the Court of Protection or anyone else have jurisdiction to make best interest decisions regarding sexual relations on behalf of an incapacitated P. So we see that as a sideshow, what you actually call it. Consent may not properly reflect where someone's trying to initiate sex, because engaging in sex would be a more natural way of describing it. But in the Act, to give Mr McKendrick his due, Section 27 does create this concept of consenting to sexual relations. As to the criminal and civil law, we say the concepts of incapacity are different tests asked for different purposes and have different answers. In the criminal law, the inquiry is very fact-specific and person-specific, looking retrospectively whether there was consent, and if not, whether there was reasonable belief in consent. In civil law, the question is prospective. Does P have sufficient understanding, retention and use of the relevant information? Can they communicate their decision? There is no requirement that they are the same. In fact, they've never been the same. Even at the time of the Munby judgments, there was still the requirement for the risk of pregnancy and STIs in the civil law, which has never been part of the criminal law test. So even taking it at its highest, the tests were not identical, even in the inherent jurisdiction days. They do need to pursue consistent objectives, which they will if both promote sexual relations as a mutually consensual activity. And then the final point is, as to relevant information, the nature of relevant information in general is that it's always relevant to the decision, as the Law Commission recognised at paragraph 3.16 of its report in 1995, that very famous report, and that's at EF 1798. So those are my preliminary remarks.
So the page number again, sorry?
I'm sorry, my Lord, EF 1798. Because that's what relevant information is. If you look at the statute, there's no discretion to disapply it in particular cases. There might be some more flexibility if you were allowed to look at the identity of the partner. But that's the irony of this case. If what you want is more autonomy, you actually want the ability to look at the particular partner. Because if it's a marriage of 25 years, you might not be too worried about the risk of an STI. That's the irony of it. The minute you create this, you create this veil behind the partner, and you just ask the question, can they consent to sex, but we're not telling you who. That is, you certainly can't vary or tailor the relevant information in that situation. Mr. Justice Hayden tried to do it in NB and
well, I think we're suitably introduced.
My Lord, I'm grateful.
We'll resume at 2 o'clock. Court's